Good afternoon to everybody, and welcome to Vincents. Welcome to our webinar, our Insolvency Law Reform presentation, in particular focusing on the changes in the recent reforms that are relevant to creditors. Just in order to introduce myself to start off with, my name's Damien Davis. I'm a senior manager here at Vincents. I've been working in the insolvency industry for approximately 15 years. I have had handle in relation to pretty much all different aspects of the insolvency profession, including bankruptcies, liquidations, administrations, and receiverships. I'm originally from Sydney. I moved up here only recently and joined the excellent Vincent team. And prior to that, I had worked in London, in the United States, and in Europe and the Middle East for various insolvency matters across there. If there are any other questions, please feel free to ask. The agenda for today's presentation is to go over the overview of the reforms and then look at the various changes based on when they're due to come in. So a raft of changes came in only recently on the 1st of March. The second and perhaps much larger and much more important bunch of changes came in or will come in on the 1st of September of this year. And then we can have a look at what other questions parties may happen to have. So an overview of the reforms. The insolvency reforms came about as a result of the Insolvency Law Reform Act of 2016 and various other introductions of the practice rules. The legislation is quite complex, and as an example of that, approximately 10% of the legislation passed last year by the federal government related to these insolvency law reforms. So you can see how the various different changes to both the Bankruptcy Act and the Corporations Act came into being. I probably won't go too much into depth into the changes to the rules, etc., just from the point of view that it doesn't really have a great deal of relevancy for creditors. It's more of an issue for people on my side of the fence. The purpose of the changes, as stated by the federal government, is to streamline the different types of insolvency, particularly between the personal and the corporate matters. But also one of the other major reasons for the changes has been to introduce provisions that would allow creditors a greater input in insolvency regimes and provide them with significantly more information from insolvency matters. You know, one of the items that has been highlighted as part of these reforms has been the conduct of certain insolvency administrators, perhaps over the last decade, and a number of high-profile matters where insolvency administrators either didn't report sufficiently to creditors or were accused of various irregularities. And this legislation is attempting to deal with those issues and ensure that those matters never arise again. Perhaps one of also the better parts of the legislation is that it's allowing insolvency administrators to better use technology that's available to them now, as we'll get on to in subsequent slides. The changes, as I mentioned, are due to come in, well, have come in as at 1 March, and there will be further changes to come in at 1 September. The bulk of changes that will be of effect to creditors will come in at the 1st of September 2017. Now, just to let you know, there are a number of changes that, or a number of minor minutiae of these changes that still need to be worked out. Recently, we had a meeting with RETA, with the Australian Reconstruction, Insolvency and Turnaround Association, so the association that governs insolvency practitioners, and they were still working with the federal government to look at some of the applications of the new legislation and the way in which that will actually apply in practical circumstances. So there may be some minor changes in relation to some of the information I'll give to you this afternoon, and if that's the case, I would be more than happy to provide an update to all parties in relation to those changes. But by and large, these are the major driving factors in the new changes. So looking firstly at the March changes, which have now come into place, As I mentioned, a lot of these have more to do with my side of the fence, with the regulation of actual liquidators themselves. Things like insurance requirements, our disciplinary matters, the way in which we obtain licensing for liquidators, and those sorts of matters. It's not really significantly based on changes that would affect creditors on a day-to-day basis. One of the matters that does come up is that there will now be a public register of liquidators and insolvency professionals that can be searched by the public. And that register will also contain details of disciplinary proceedings that have been taken out against that liquidator or insolvency professional, and also will include any matters that have been put on their file, any restrictions. For instance, you may have liquidators that are required to hold or take joint appointments in relation to jobs. They can't take a job singly, and those sorts of various matters. The reasons for those changes isn't necessarily always nefarious. Newly registered liquidators will likely have a requirement that, say, for 6 months, they would take joint appointments with a more senior and more experienced liquidator, for instance. Further on into the March 2017 changes, the role of the official liquidator has now been removed. The official liquidator only was appointed over court liquidations. And now the other part is that bankrupts are now known as regulated debtors, which I can assure you is causing significant issue in terms of changing our correspondence and our various reports to creditors at the moment. One issue that is of relevance to creditors is the notion of the relation back date. What had been happening, or one of the loopholes in the legislation that had previously existed, was that where a party was looking to appoint a voluntary administrator, and it had creditors that were pushing in relation to the matter, they could effectively have a creditor bring proceedings to court looking to wind the company up in a formal manner, and then go and appoint a voluntary administrator and get the benefit of the relation back date only being the date that they appointed the voluntary administrator. The new legislation changes that as of 1 March, and effectively, if a creditor brings a winding up petition, the relation back date will be the start of that will start when that winding up petition is served. And so accordingly, that would mean that liquidators in general will have a slightly further period in which to look at things like preferences, insolvent trading, and those sorts of uncommercial transactions that can be recovered in matters. The other issue, perhaps of credit that's of benefit to creditors, is that declarations of independence and relevant relationships and also indemnities will be now lodged with ASIC. Now, again, as I mentioned before, there are some issues that need to be worked out in relation to this, but as it stands at the moment, that provision of DIRIs is only applied to voluntary administrations. It will apply to all the other forms of insolvency coming 1 September of 2017. I don't know exactly how many people are affected by this, but the voluntary administrator will be, when appointed and disclaims property in relation to a matter, must disclose the location of that property. Now, that was a significant factor in relation to particularly a number of mining jobs that occurred recently, where the voluntary administrator just disclaimed the assets and effectively left it to the leasing companies to find the location of those assets. One of the provisions is now that we should conduct appropriate investigations to find out the location of those assets, and if at all possible, disclose those to the parties. Again, directors must notify the deed administrator of any provisions, of any breaking of DOCA provisions, the deed of company arrangement provisions, and again, the liquidator must inform the creditors of those provisions being broken and effectively give creditors an opportunity to take steps in relation to that. The final matter is that insolvency practitioners can now apply to a court to have the company's name removed from documents. That occurs occasionally where you may have a company that or a business that is sold by the liquidator or by the administrator, and the business name is sold, obviously, as part of that, and the company's name then gets converted to an ACN. And there's now a provision to allow the liquidator to remove the company's former name from public documents and correspondence, and allow the business to trade freely. The other matter that has come up is that liquidators are now in a position to be able to transfer or to sell rights in relation to uncommercial transactions, in particular in relation to preferences. And so there is an opportunity for creditors now to negotiate with liquidators about acquiring an interest in a preference. The formalities of that matter are still being worked out with ARETA, our regulatory body. At this stage, we haven't come across any circumstances of that occurring, and I don't know of any in any other firm either. There would potentially be a limited opportunity for that to occur. It would need to be something that would be considered by any liquidator in relation to their other obligations to creditors in a matter. So that was the major component of the March changes. As I say, of those March changes, there's probably another 8 or 9 slides that I could have done that are entirely based upon the regulatory aspects of liquidators themselves, the amount of insurance we need to carry, our professional qualifications, the matters that we're allowed to deal with generally, our regulatory and disciplinary procedures, all of which I don't think have any significant impact upon creditors themselves, and so I've missed them for today's for the focus of today's presentation. But if any party would like me to provide you with further information in relation to that, please by all means send me an email, and I'm more than happy to take those through through those new changes. So in relation to the 1st of September 2017 changes, this is actually the bulk of the changes. This is the changes to the actual progression of an insolvency administration. And so the changes that are here affect the actual conduct of each matter that will be done by liquidators from here on out. Again, as I mentioned, there are certain aspects of these changes that need to be worked out in terms of a practicality sense. And so there may be some minor changes in relation to these going forward. One of the matters of the new rules and the new legislation is that a lot of these changes are now based upon rules, or what's known as rules. And the view that we've been explained, or has been explained to us, is that these rules are capable of being changed by the minister without further input from Parliament. And so accordingly, a number of these changes that have been brought in, there's a view from at least the government perspective that more practical aspects of their application can be altered and changed on a regular basis and without too much fuss by the minister, should that practicality arise. Now, whether or not that actually occurs is something that we'll see going forward. So in relation to external administrations generally, both corporate, well, mostly corporate matters, there's changes as to when meetings are required, the use of casting vote, use of special proxies, and the ability to corporate matters to have proposals without meetings. One of the matters that has arisen from these changes is that essentially they've tried to both streamline the process for insolvency and, as I say, give creditors more of an input. So creditors have more of an ability to determine whether various meetings should be held, and insolvency administrators conversely have more of an obligation to report to creditors on a regular basis, as we'll see. Again, as I mentioned earlier, one of the good points that I find about the changes is that electronic communication has increased, the use of it. One of the things that we're able to do now is to send out a circular to the creditors and advise them of where our reports are being saved on the system or saved on the internet, and provide them with a link to that site, and then have the creditors go in, log into that site to access those reports. Creditors conversely are able to write to us and say, well, we don't want an electronic copy, and request a written record, but in the first instance, the electronic copy will be sufficient. Again, that'll probably result in changes to the Vincents website over the course of the next 6 months, to allow for us to store and have access to those reports on our system. We generally provide paper copies of those reports at the moment, but we're always happy to email those reports, and we include details for email addresses in our reports as a general course anyway. Again, as I mentioned, one of the major aspects of it is to ensure that creditors have more oversight in relation to the process. And so creditors' requests for information are now dealt with in a more formal structure, in particular ensuring that the reasonable requests are attended to by a liquidator in a quick and timely manner, and there's actually a structure in place to deal with that, and we'll go into that a little bit further. So looking at creditors' voluntary liquidations, which I suspect are probably amongst the most common insolvency appointments that creditors and other professionals are likely to see. As I mentioned earlier, with the voluntary administration process, declarations of independence from relevant relationships will have to be lodged with ASIC from the 1st of September 2017, and they will be publicly accessible. Excuse me. So that you can be able to see what relationships the various liquidators have with the parties that they're liquidating. Creditors will be notified of their appointment and their rights within 10 business days. Now, this is not particularly dissimilar to the current arrangements that we have, in that I think it is that we have to send a report out within 11 business days, and hold a creditors meeting within 7 days after that. So effectively, on a creditors voluntary liquidation, you're looking at the reports coming out more or less on the same sort of time frame. Now it's a 10 business days issue. One of the issues there is to be notified of their rights, and we'll go into a little bit more into detail on that a little bit later. But it's more just a matter of the format of the report and the issuing of that report. Now, as I mentioned, the major change in relation to that is that there's no compulsory initial meeting now. So as it has stood and currently does stand, a creditor, once appointed, an administrator will issue a report to creditors within 11 business days, and then hold a creditors meeting within 7 business days after that. The position now is that the liquidator will not have to hold that initial creditors meeting. However, creditors can request that meeting at any time, and in order to do so, effectively, the administrator must get 25% of creditors in writing to write to him. Now, there are a few other changes. In the first 20 days, for instance, it could be only 5% of creditors of no value writing to the liquidator and asking him for a creditors meeting to be held. So there are going to be a few changes there in terms of monitoring, when that period expires, and having liquidators, receive the appropriate correspondence from creditors. But again, as I mentioned, it's effectively driven at creditors here to be able to know exactly what's going on, and to effectively drive the process themselves. If they want to call a meeting, they're entitled to call a meeting at any point in time. They don't have to wait for the liquidator to convene a meeting or make any court application to convene a meeting or anything else like that. They have a simple methodology in order to call that sufficient meeting, and those meetings cannot be refused by the liquidator in the circumstances that they are available. The other issue, as I mentioned, in relation to our reporting requirements, is now that the liquidator must issue a further report to creditors, and that report must be issued within 3 months. That report will also be lodged with ASIC, and that report will be significantly more detailed and will provide details of a likely dividend in any particular matter that we're appointed to. I'll go further into the nature of that report a little bit later. So there is the swings and roundabouts, I guess, side of aspect of that is that we no longer have to provide annual meetings or reports to creditors. There's no longer any need to hold a final meeting in respect of court liquidations. How that necessarily benefits people, I leave that up to you. In relation to a court appointment, again, very similar style changes here under the legislation to the creditors' voluntary liquidation. As I noted previously, there's no longer, as of the 1st of March, an official liquidator title. We're just liquidators, whether we're court appointed or appointed by a voluntary process. In relation to court liquidations, given obviously our access to information, creditors are to be notified of their rights and send a report within 20 business days. Now, to be perfectly frank with you, this would, in a number of court liquidation circumstances, be difficult, particularly in matters where we're unable to get in contact with the directors. We have insufficient information. We're unable to contact any professionals to provide us with any of that information. And again, this is one of these matters that ARID is trying to look at the practicalities of how this would work, and what sort of impact that would have if we receive absolutely no information. Obviously, in respect of a court liquidation, we would know who the petitioning creditor is, but occasionally, the business is closed, the forwarding address is no longer used, those sorts of circumstances occur. And in that particular case, it can be difficult for us as liquidators to be able to advise creditors of our appointment and their rights within the time frame as suggested by the legislation. Again, creditors can request a meeting at any time. Again, it's based on the same set of circumstances. Again, a liquidator must issue a report within 3 months advising creditors of the likelihood of a dividend, and that report will be lodged with ASIC. The other major change that will come in as of 1st September, this is probably one that will impact clients of solicitors and creditors generally, particularly those creditors who do seek to take winding up applications. The current arrangement is first cab off the rank situation, in that, in general, where a liquidator is approached either by the court or by a creditor to take a court liquidation, unless there's a conflict issue, they generally are required to take that appointment, whether or not there is assets there to recover for the liquidator. Under the new legislation from the 1st of September, those requirements are now removed, and that a liquidator can refuse a court appointment on the basis that there are no assets. That also opens the door for a liquidator to request and receive a indemnity or a payment up front in respective court liquidations. Again, I am unsure exactly how much this is necessarily going to help circumstances. There are plenty of matters currently that I have where liquidators have been appointed, our officers have been appointed by a creditor who has obviously lost a substantial amount of money and is not particularly inclined to fund me for the process, but is aware that, or is reliant upon my investigations to generate either my fees or a return to creditors. So again, the practicalities of this are going to be interesting to see, and in particular to see whether creditors are actually in a position that they receive any significant advantage in relation to this method of appointment, or whether there are going to be a number of matters there where creditors are subject to disadvantage simply because the liquidator is unable to justify that there are fees within the matter, and is therefore unwilling to take the court appointment as seen in the legislation. The voluntary administration and the deed of company arrangement process. There aren't a particular number of changes here. The legislation remains very much as it is. Again, under a voluntary administration process, the reporting guidelines are very strict. They're perhaps a little bit looser in relation to court liquidations and in relation to creditors' voluntary liquidations, particularly after the first notice of creditors is issued. It may be, in certain cases, anything up to 12 months or 18 months before a liquidator will issue a report in relation to those matters if his investigations are ongoing. Voluntary administration, however, has strict timeframes, and 2 reports need to be issued, obviously, within the first one issued pretty much immediately on appointment, the second one within 21 days or so. The report is now lodged with ASIC, where it wasn't previously, and it will be on a register available to the public. Again, as I noted previously, these reports are available to be issued electronically and will generally be held on the liquidator's website if that's the way he wishes to do it. The removal of the incumbent administrator is now possible to occur at the second meeting. It has always been available at the first creditors meeting. It's now also available at the second. As noted, there are strict rules in terms of having 2 creditors meetings prior to making the decision to put a company either into liquidation or under a deed of company arrangement. And accordingly, the new rules don't introduce any significant changes to that, and creditors don't have any rights to request additional meetings in the voluntary administration process. The matter proceeds as it has previously. Regulated debtors estates, which are obviously old bankruptcy estates, and that's very difficult phrasing to get around. The procedures are largely the same. There's not any significant changes in the legislation for regulated debtors estates. A couple of minor changes in that the liquidators now need to seek, or trustees rather, now need to seek approval from creditors to have related parties paid. And in relation to that, that would be something along the lines of if the trustee engaged an accountant serving within their practice to, say, prepare the regulated debtors' tax returns. Any sort of work of that nature would need to be approved by creditors in terms of its remuneration. The other part of it is that the chairman now has a casting vote at the creditors' meetings. This previously wasn't the case, particularly in relation to ordinary resolutions. And so that sort of just changes up those numbers slightly. Now, as I mentioned, reporting to creditors. So there are some changes to the legislation. As you would have noticed previously, in both court liquidations and in CVLs, there is a requirement by our liquidator to issue a 3-monthly report to creditors, which will provide a indication of the likelihood of a dividend. Creditors are also to be informed of their rights, and as I've noted previously, those rights include the ability to request information, reports and other documents, the ability to request a meeting at any point in time, the ability to give directions to the liquidator, and the ability to appoint a reviewing liquidator or to replace the administrator. We'll go through these rights subsequently, but again, there are certain aspects of the legislation that haven't yet been worked out. For instance, the give directions notification. As it stands at the moment, there isn't any particular direction as to what those directions are and what obligations the liquidators have to follow those directions or to follow up on them. As you know, there will be certain matters that we perhaps can't investigate due to our powers, or there may be other vexatious claims. So we're still awaiting further direction in relation to what exactly that phrasing will end up meaning. As I mentioned, with the report requiring the likelihood of dividend within 3 months of appointment, the report will have to provide an estimate of the assets and liabilities of the company, the investigations undertaken to date by the liquidator, and details of any further investigations that the liquidator will seek to undertake, outline the possible recovery actions, and that report must be issued even if there are no funds or no funds have been recovered at that point in time in the liquidation, and the report will need to be lodged with ASIC. The report will be very similar along the lines of the 439A report that's provided in a voluntary administration at this point in time. Anybody who's seen that report will know that it's very detailed and provide a significant detail of the company's financial position and the possibility that the liquidator has of recovering assets or undertaking further investigations in relation to a matter. There is a little bit of question within the profession itself, obviously, of how much of this information you're going to be able to provide within that 3-month deadline, particularly given that we may not get responses from accountants, we may not get responses from solicitors, we may not have responses from companies within that period of time. So there is a bit of a question as to that. The other question is that in circumstances where a company goes into voluntary administration and then subsequently goes into CVL, when does that 3 months start? As it currently stands underneath the legislation, the 3 months would actually start at the start of the VA process. And accordingly, in circumstances where the creditors' meetings are adjourned or delayed, there is a position there where you're effectively having to write these 3-monthly reports immediately upon your appointment as a CVL liquidator, or even potentially before the liquidation comes into effect. So again, those sorts of issues will need to be worked out on a practical issue, and hopefully will be resolved over the course of the next 6 months. So requests for information. Creditors now have significant power to request information from the appointee. As a general course, I think certainly most of the liquidators that I work for, both here and overseas, do everything that we can to ensure that creditors have information that they make requests of us. This is just perhaps a more formal matter of the process. Essentially, what will happen is that where a creditor makes a request for information from a liquidator, the query will become whether that request is reasonable, and it will be held to be reasonable unless there is good faith on behalf of the liquidator that supplying the information would materially prejudice other creditors, or the liquidation generally, or another third party. The information is subject to professional and legal privilege, that the information has already been provided within 20 business days, that there is no sufficient property in the administration, or if the request is vexatious, i.e. it's made within 20 days of a previous request. The last few items in relation to the fact that it's been provided within 20 days, there's no sufficient property in the administration, or that the request is vexatious, can be overcome if the creditor agrees to pay the cost of providing that information to the party. So in these circumstances, it's quite clear that the majority of requests that we would receive from creditors in relation to information will be considered reasonable. In the event that they're not considered reasonable, the liquidator will have to provide a written response to the creditor, outlining the reasons why they believe that the request is unreasonable. In the event that it is reasonable, we have 5 business days to provide the information pursuant to any written request. That can be negotiated slightly higher if the information is voluminous, but in general that has to be complied with, and certainly the creditor has to receive a response in relation to their request within that 5 business days. Meetings, as we've noted previously, particularly in relation to CVLs and to court liquidations, there is now no requirement to hold a meeting. However, creditors now basically have the driving factor of being able to request meetings whenever they so wish. The position changes in respect of various timelines that apply. And in CVL, the first meeting will only occur where between 5% and 25% of creditors who are unrelated make a request, and that request has to be received in writing. As I noted previously, within the first 20 days of a CVL appointment, it only requires 5% of creditors to request a report. Other meetings will occur when the Committee of Inspection directs the liquidator to hold a meeting, where there is a resolution by creditors. So, for instance, if at a first, say we're appointed as CVLs and people request a meeting, and then at that meeting they then request that we hold another meeting within, say, 6 months of the first meeting, then we're obliged to hold that meeting. Even more than 25% of creditors make their request in writing, or less than 25%, and they provide security for costs in relation to the holding of the meeting. So, again, it has a significant level of involvement for creditors. Obviously, creditors with a significant debt in relation outstanding to any particular company have more power than probably smaller creditors, because they would be more likely to comply with these debt limitations. But I suspect that it also encourages creditors to communicate in relation to these procedures, to have liquidators continue on with the process. Now, in relation to these matters, again, as part of the streamlining between the Bankruptcy Act and the Corporations Act, the position now is that corporate appointments also are capable of having proposals without meetings. It's an option that's currently available in the bankruptcy proceedings, and effectively it would involve the liquidator sending out a report to creditors saying, I wish to have this proposal passed. I don't think it's financially relevant to hold a meeting, and then effectively asking creditors to vote on the process. The proceedings of the matter will require that each proposal has a separate voting slip, and that effectively creditors have 15 business days to respond by providing that voting slip back to the liquidator. The chairperson of the meeting, of any creditors meeting that is convened by the creditors or called for by the creditors, must invite resolutions and amendments from the floor and allow sufficient debate of those proposed resolutions. Again, this is a matter that we're looking for further specifics in relation to how this Act is supposed to operate in a practical sense. The chairperson may adjourn the meeting of creditors without resolution, and that's again a change to the current matter where we need to require creditors' resolutions, and all claims and proofs must be dealt with, and there must be evidence of how they're dealt with. It also requires us to lodge the attendance register with the minutes of the meeting and have those publicly available. There is also a second, and again, we're looking at the practicalities of this. Proxies cannot be used for resolutions with a financial interest. That applies to special proxies and general proxies. Effectively, as it's written at the moment, this would require the liquidator to have creditors attend the meeting. However, again, the practicalities of this are still being worked out by a reader. There's a bit of an issue in that we believe that it's believed by the profession that this resolution or this particular part of the Act is effectively applying to general proxies and not to special proxies or specific proxies as they're otherwise known. And that's where a creditor would indicate to the liquidator exactly how they want to vote in relation to a process. So that's meetings. The other power that's significantly increased has been the ability for a creditor to replace the liquidator or the trustee, and they can request a meeting to do that at any point in time. Again, by the same processes of 25% of people requesting that vote, or 5% in the earlier position. The liquidator is required to give 5 business days notice of that meeting of creditors, and the incoming party or the party that's looking to replace the incumbent liquidator must provide their DIRI, their Declaration of Independence, to be issued in accordance with the correspondence. It only requires an ordinary resolution, no longer requires a special resolution to remove the liquidator. There will, however, be 2 resolutions that are required. The first one to remove the liquidator, the second one to appoint the replacement. And if the first one is passed but the second one isn't, the incumbent will remain in place. The incumbent is also able to challenge the replacement in court based on information that may be received. So if a related party or a vexatious creditor has effectively taken steps to remove a liquidator in order to prevent some degree of investigation or something like that, the liquidator can apply to the court to have the matter looked at. The costs of that need to be set to one side and accounted for separately as a separate process to the cost of the actual liquidation. This particular replacement aspect will apply to all matters from 1 September. So liquidations that are appointed, or liquidators who are appointed now to various liquidations, will also face these matters and can be removed come 1 September. The other, I guess, significant issue is that there's now an ability for creditors to request a review of external administrations and estates, and a review particularly of the liquidator's conduct. As it stands at the moment, the legislation relates strictly to the remuneration of the liquidator. In particular, they can appoint a reviewing liquidator to look at the conduct of an incumbent liquidator, in particular in relation to his remuneration incurred in the last 6 months prior to the request. The scope of that investigation and the fee is set by the creditor. So a creditor might approach me to look at another liquidator's remuneration package and how he's incurred his fees and whether those fees are reasonable. The court does have the ability, both the court and ASIC do have the ability to appoint a reviewing liquidator to look at any other matter. That's not dissimilar to the current set of circumstances, but it probably changes a little bit, and it's usually the court or ASIC that actually does the investigation. Now they'll look at it, they'll have a reviewing liquidator, and that liquidator might look at how assets were sold, what investigations were undertaken, what pursuit of what proceedings were done, whether any matters were overlooked, and essentially that reviewing liquidator's report, he'll provide that back to the court and to ASIC. It won't be a final judgment, but effectively it'll be just a background of what the proceedings were, and then it'll be up to either the court or ASIC to make a final judgment in relation to the matter. Unfortunately, these applications, particularly reviewing trustee, doesn't apply to regulated debtor estates. That power still remains with the Inspector General of AFSA to pursue those matters in relation to bankruptcy proceedings. Finally, committees of inspection. I guess they will potentially have more of relevancy, particularly in relation to liquidations, where there may not be a requirement to hold regular meetings by a liquidator, including annual meetings. At the first creditors meeting, should one be convened by creditors, it may be relevant for them to look at appointing a committee of inspection. Creditors with 10% or more of the debt can appoint a representative. Employees can also appoint a representative. One of the significant changes to the current legislation is that the appointment is now by the creditor and not by the representative. The previous circumstances had been that the way the legislation was written and interpreted by the courts, the appointment, if Joe Blow from XYZ company was appointed, it was Joe Blow who was the representative. And if Joe Blow happened to leave XYZ company, then that company would no longer have a valid vote in respect of the body, the committee of inspection. Now the situation will be is that XYZ company is the representative and Joe Blow is their representative on that committee. If Joe Blow leaves, it's not going to matter. So that makes things a little bit more practical for us, as it obviously becomes an issue where you've got a multi-year liquidation proceeding, particularly a very complicated one, and you may have representatives leaving their positions or leaving their firms, and it becomes quite difficult for us to deal with that. Committee of inspection meetings now need to be advertised, and both ASIC or the Inspector General, depending on whether it's a corporate matter or a bankruptcy matter, can attend the committee of inspection meetings and have an automatic seat at those particular matters. The other matter that is significant, particularly in relation to corporate matters, as it currently stood, based on the way in which the courts were interpreting the legislation, a liquidator would be required to not only get consent of creditors to hold a committee of inspection, but also would need to get the consent of members at a separate meeting to hold that committee of inspection. It's now been removed that contributors, i.e. members, shareholders, have any influence on the matter. So effectively, if creditors resolve to hold a committee of inspection, then that's it. The committee of inspection will be formed. A committee of inspection can request information or direct the appointee, and those requests for information and those directions fall within very much the similar rules as we've discussed previously in relation to requests for information, i.e. they need to be reasonable, and if they're deemed to be unreasonable by the liquidator, he needs to provide in writing advice as to why that's the case. So that's really the general position as it stands in relation to the Insolvency Law Reform of 2016. I hope this presentation has been of some assistance. It's a very general overview of the process, and in particular the focus on the ability and the increased rights of creditors in the matter. And should you have any further queries in relation to this matter, I look forward to receiving any emails from you. My email address is there, ddavis@vincents.com.au. I look forward to receiving those for you, and more than welcome to take out some time to go through those processes for you. If you have any queries generally in relation to insolvency matters, by all means feel free to contact me. No obligation, no cost, more than happy to discuss those matters with you. And at some length, come out and meet with you and look at what the issues are and see what we can do to help. I hope this presentation has been of benefit, and look forward to providing further information to you in due course. Thank you very much. Cheers.